Pardon?
I don't agree.
Okay, what don't you agree with?
Just in,
Calls the case, People versus Kanasia Johnson Jackson.
Robert Mullen on behalf of the defendant, Your Honor.
Your name? Yeah.
Kenya Johnson Jackson.
All right. And this is actually, I think, a time for a PCC and your motion to withdraw.
Yes, sir.
All right, go ahead with your motion to withdraw.
Your Honor, I put most of the important facts that I think that are necessary. If the court wants details, I'm more than happy. But I believe based on the rules, if I have a financial hardship and continued representation, the court would take that in as a reason for withdrawal. But more importantly, if I can withdraw at a time which will not create any kind of substantial hardship on behalf of the defendant, and I think that would be the case here. We do have all the discovery that we think we're entitled to at this time, but we have not had a preliminary exam. And I don't believe that any of my clients' rights have been prejudiced.
And Ms. Johnson Jackson, anything you want to say regarding Mr. Mullen's motion to withdraw?
Yes, I don't agree with it.
Pardon?
I don't agree with it.
Okay, what don't you agree with?
Just in, based off the language that was provided to me in reference to, can I see your paper?
Absolutely.
The one that's under the-
Oh.
It's in there, like, way down. The email that you sent me this morning.
You want the motion? You want the, didn't you read me something?
Yeah, that's what I'm talking about, the email that
Oh,
was.
hang on.
Thank you.
Mhm.
So this morning, the email that was sent, which is what I'm about to read, it says the defense counsel appear on behalf of the defendant with the understanding that defendant will be remitting forthwith to defendant counsel a retainer payment as agreed upon by defense counsel and defendant. The second one was defendant subsequently failed to remit said retainer payment, nor has defendant indicated when the retainer will be paid. 1 second. The third one is an attorney may withdraw if his client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So in reference to all that, yeah, in reference to all that stated, the retainer, so him and I, it seems like there is confusion between him and I in reference to the retainer fee and just like the distance of my case. Does that make sense?
No.
So I don't agree. So what he's doing is a motion, right?
It's a motion to withdraw as your counsel.
Right. So I don't agree with the motion to withdraw in reference to this is my probable cause hearing, right?
Well, it is a probable cause hearing, yes.
Right. So, okay, so I have a question. So with him withdrawing as my counsel, are we still doing this today or is that postponed?
If he withdraws, okay, ma'am. So I have to make a determination as to whether or not there are grounds to withdraw as
Understood.
I'm looking at it. So I asked, Mr. Mullen stated his position. I have the motion in front of me, and I'm asking what your position on this motion to withdraw is.
Oh, I absolutely disagree. And to my understanding, it seems like most of like videos and just maybe more statements have been given to my defense, but to my understanding, that is the discovery, but I don't know anything about it because him and I haven't spoke about it. Does that make sense?
Okay, it could, yes.
Okay.
So, ma'am, let me just ask you this. His basis of withdrawing is that you were supposed to you had certain financial obligations. It's indicating that you haven't fulfilled those. I don't need to know what those specific terms are because it's not relevant to at least the court's determination at this. Are you indicating to me that you did fulfill those obligations? And
Yes.
therefore, okay, but fully fulfill those obligations?
I haven't fully fulfilled obligations, but I have put money in his hand. So that's why, yes.
Okay,
Jenna, may I respond just, or do you want me just to be quiet?
go ahead, go ahead.
Yeah, she's right. She's paid me some money, of course. But the reality of it is, it's less than a third of what the retainer understanding was an agreement for this case. In addition to that, I haven't paid anything in almost 3 months. There's been no efforts to pay me. I've had multiple meetings. I had a meeting on the 26th of June specifically to make this a focus. I don't like talking about money. I'd rather work as a lawyer and do the work on the case and have those meetings. But as you know, it becomes a conflict of interest when you're not being paid. This is a capital case. She's entitled to substantial work on this case as it being a capital case. And when I'm not getting paid, I don't know how I'll be able to do it. This is not like an OWI where even if I'm not getting paid, I could probably suffer through it and it wouldn't damage my practice or my mental health. This would be maybe a little more of a different of a situation. But to say that she hasn't paid me any money,
I don't think that you said that.
I just want to make it clear she has, but she has not even come.
That's not what I got from this. I get it. So, ma'am, are you telling me? I understand that you've paid part of what's there,
Yes.
okay? But you haven't paid what the entire amount agreed upon was.
You said what the entire amount?
What the entire amount, you haven't paid that.
I haven't paid the entire amount.
Okay, so are you telling me that you're going to?
What I'm saying is there has been some confusion in reference to the amounts. There has been efforts, multiple efforts to make payment, and I have made payment. I have not made the entire amount. But
So let me just ask you this. As to the entire amount that was requested to obtain of the retention, why hasn't the full amount been paid?
because there was confusion on the full amount.
Your Honor,
I don't know what that means.
Miss Jackson Jackson wrote me out a payment schedule. This was her schedule. It wasn't my proposed schedule.
Yeah.
She wrote me out a payment schedule and provided it to me and has not even lived up to that. And like I said, less than a third of the retainer in the case. And just so this court knows why I'm a little nervous on top of it is, and I explained this to her, I have a bifurcated billing system. Part of it's a retainer, that's a flat fee. The other part is an hourly when we get into motions and trial. And the fact that we're having such an issue with just the base retainer, I'm nervous. We go further in this case. We get into trial, we're going to have an hourly bill that's going to be accumulating, and I don't have confidence in that bill being paid timely. So hence the motion.
Ma'am, is he right? You laid out an agreement that you were going to pay?
We did have an agreement,
Ma'am, can I ask you why you just don't answer my question?
because
I think my questions are rather simple. Mr. Mullins has indicated you laid out a payment schedule to him. Is that right?
yes, but it wasn't the total amount being asked. The payment plan that was laid out was not the total amount that is requested. And so when I understand, when I say that there is confusion in reference to it, usually, for instance, people will sign a retainer fee with the lawyer, and that didn't happen. So once again, I did give him money to counsel me. But as far as the total amount, it wasn't.
Then ma'am, explain to me something.
Mhm,
If you haven't done that part,
mhm.
why shouldn't I grant his motion and just let him withdraw?
Because this is the probable cause hearing.
Because what?
This is the probable cause hearing.
Okay, and I give you another probable cause hearing. You won't be in any worse position
Mm. Okay,
because that's his obligation. His obligation is not to put you in a worse position when he goes to withdraw. And so that you understand what Mr. Mullen is really saying, and maybe he says just more fancy way than I would. He doesn't want to get to the point where either you're not paying him or something else happens in the case, and then he's either stuck because he can't have you in a safe spot, or he just has to try to get out to save himself, and you're going to be in a worse spot.
I understand.
So can you tell me a reason why I shouldn't let him out?
So I have a question. Can I ask a question?
Sure.
So with, let's say that you ruled that he in his favor. So this would be, it would be, so I would be given a,
Ma'am, let me stop. I'm going to tell you what I'm going to do. Okay? And that way we can just put this to an end. I'm going to grant his motion to withdraw. I get it. I think you're a little bit worried that you're going to be left out there on your own. Here's PCC and whatever. Doesn't work that way here. So I'm going to grant Mr. Mullen's motion. Mr. Mullen is withdrawn from the case and further discharge of any obligation of this client or the court on this matter.
Thank you, Your Honor.
This now becomes a public defender case. You're represented by the public defender at this juncture, okay? That way you still have counsel, very capable counsel to represent you in this matter. Ms. Anderson, thank you.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Johnson Jackson. Your Honor, I asked for a couple weeks adjournment for us to get discovery and speak with her about the case.
All right. All right. Probable cause conference in this matter will be adjourned to July 25th, 2024 at 9 a.m. or as your invite indicates. Okay? Ms. Johnson Jackson, you understand?
yes,
Okay, so you've got counsel now. They'll get the discovery. They'll be able to go through it with you and pace through it. It doesn't mean if you want to hire another attorney or somebody else, you can still do that. But you've got very, very capable, extraordinary counsel to represent you. So,
I understand.
okay. And so bond will continue.
Thank you, Your Honor.
Thank you.
Oh, okay.
Mr. Kittle, thought that was it.
We're ready. Oh. We've been ready for the last half. And then the judge came charging off the bench. Heck, yo. All right, court, let's call the case. People versus Wardell Smith.